Okay, so good evening, everybody. I have a great pleasure to chair this panel. We have today excellent panelist, Mr. Prabhat Agarwal, the head of the Unit Digital Services and Platforms of the European Commission. We have with us Professor Christoph Busch from the University of Osnabrück, who is also now the fellow of the Yale Law School Information Society project. We have Gerhard Dannen, professor of the Humboldt University and also University of Oxford. Here we have Rania Wazir, board member Diana Datachen, and Aneta Wiewiórowska-Domagalska from University of Osnabrück. Finally, myself, also University of Osnabrück and University Jagiellonian University. What we can see here from the academic world, the majority represent more than one institution, so it's also quite a particular event from this perspective. But our topic for today is, has, I think, a great utility for ELI, for European Law Institute as such. We want to use the example of the model rules which have been in the European Law Institute as one of the first model laws, or even the first model law of the European Law Institute on online platforms. And then, of course, we have, at this example, we should discuss whether these online platforms, not online platforms, but model rules, are a good device for developing the law. And is the question the law where? So the law of the European Union, but the ELI is broader than the European Union. So the law in Europe be an inspiration for different countries, but also maybe for European legislation. ELI has been somehow is following the model of the American Institute, and also a different legal environment and different challenges. And of course, the idea of having kind of model rules or restatements, it was the idea which has been also taken some partial, and of course to our circumstances. But when we have to check out whether this is exactly the device which Europe does need, or it is something which must be more adapted to the particular European circumstances and conditions. But we want also to discuss a little bit in practice here, and therefore we have also members of our panel who are not members of the drafting committee for the model rules, discuss a little bit whether our model rules had impact on the European legislation and are useful at all, or it is something only a kind of academic exercise which could be sometimes discussed at the coffee, but without real impact on something. So I think this is our challenge, and I have great pleasure to introduce our first speaker, Christoph Busch, who will exactly discuss, I think, this matter in the context of our model rules, in the context of the development of European legislation from the academic perspective. Christoph.
Thank you very much, Frederick, for the kind introduction. I would like to kick off our discussion with a few remarks on how the ELI has already contributed to the policy debate on the Digital Services Act package, and where possible areas for future ELI work might be identified. And I've prepared a presentation which I would like to share with you, and I hope that it's working. So As I said, I would first like to say a few words about how ELI has already contributed to the policy debate on the DSA, where platform regulation might be heading after the DSA. The DSA will certainly mean a certain plateau of platform regulation in Europe, but at the same time, certainly not the end of the story. There are already other pieces of legislation in the pipeline that are also relevant for online platforms and where ELI might contribute some thing useful. And in this perspective, I will talk about ELI's future role or potential future role in the policy debate. So far, I think the main contribution of ELI to the policy debate are, of course, the model rules on online platforms that have been elaborated by an ELI working group over several years and that have been published in February 2020. And I'm happy to say that our work has actually been taken up by several stakeholders like BUC, the European Consumer Association, but also by the European Parliament. If you look at the European Parliament's resolution, which was adopted in October 2020, so just before the DSA proposal was presented, the Parliament called for the DSA to address the liability of online marketplaces where those platforms have a predominant influence over suppliers. And if you're familiar with the ELI model rules, this wording echoes the wording of Article 20 of the ELI model rules, which concerns the liability of online platforms exercising predominant influence over the supplier, or more precisely, cases where the customer can reasonably rely on the platform operator having a predominant influence over the supplier. When the DSA was published in December 2020, this call by the European Parliament was not taken on board as it was formulated, but a provision that comes close to what the European Parliament has called for is maybe Article 5, Para 3 of the DSA, which essentially is a carve out from the liability privileges of Article 5 with regard to liability under consumer protection law in cases where an average consumer may believe that products or services are provided by the online platform itself or under its authority or control. And instead of using the term predominant influence, the term control is used here. So it's about the concept of apparent control. More recently, interesting, just a few days ago, you will probably have seen this already, the European Parliament, or more precisely the IMCO committee, the rapporteur on the DSA, Christel Schaldemose, has published her draft report, and she calls for an amendment of this Article 5 that I just referred to, and she suggests to add a paragraph with a list of indicative criteria to identify whether a platform exercises control or decisive influence. And there is this list of criteria that you can see here. And again, if you compare this with the wording of the ELI model rules, this is in some parts verbatim from Article 20, Para 2 of the ELI model rules with some adaptations here. So apparently the ELI work has been taken up as a source of inspiration by some of the actors in the legislative process regarding the DSA. Whether these suggestions will make it into the final version is an open question, of course, but I think at this time the ELI should rather look beyond the DSA, as the title of our webinar says, and look what could be further fields of activity for the ELI with regard to platform regulation. And I think, to be very brief, there are several legislative proposals, initiatives in the pipeline. Just think of the upcoming revision of the General Product Safety Directive announced under the new consumer agenda, where, of course, the question of responsibility of digital platforms for product safety will be a major issue. And there is also a process of updating the guidance documents for the Consumer Rights Directive and the Unfair Commercial Practices Directive. And as these directives have been updated by the New Deal for Consumers, the Modernization Directive, the question now arises how these directives will apply to digital platforms. And maybe the ELI can contribute to this update of the guidance documents, which play an important role in practice. Then, of course, there's also the upcoming revision of the Product Liability Directive, which, among other things, will address the thorny question of product liability of online marketplaces, where again, the question of platforms exercising control over transactions will arise. There's also the upcoming evaluation of the P2B regulation, the platform to business regulation, which is due in 2022, and which will definitely have to address the question how the P2B regulation, maybe in an amended form, will interact with the DSA and the DMA. What will be the role of the P2B regulation in the new regulatory landscape that will be shaped by the DSA and the DMA? And I think ELI could also contribute to this part. And then there is a less obvious piece of legislation, that is the planned corporate, the new rules on corporate due diligence and corporate accountability in the supply chain. And so far, the policy debate on this dossier has very much focused on traditional importers that import products into the European Union, or that are producing in the European Union on the basis of imported raw material. But the question may also be asked, what is the responsibility of online marketplaces for supply chains, considering the large amount of products that are entering the European Union through such online marketplaces? It is certainly not feasible for online marketplaces to check each product from smaller suppliers. But what about the high volume suppliers, the 5 biggest sellers on Amazon? Would Amazon be required to verify the supply chain of these high volume suppliers? I think that could also be a debate where ELI might contribute. And actually, ELI has already started contributing to these upcoming debates. Just think of the recently published guiding principles for updating the Product Liability Directive drafted by Christian Twig-Flessner, where guiding principle 5 suggests to revise the category of persons liable, the category of producers or importers, and the guiding principles refer to recent case law from the US, Bolger against Amazon, or the more recent Loomis against Amazon case, 2 California cases addressing product liability of online platforms. And I think that would also be a field where ELI could definitely contribute already on the basis of the existing model rules. And then I think there's another field where there is space for ELI work, and that is platform procedure. I think we are seeing a procedural turn in platform regulation. If you look at the more recent pieces of legislation, be it the P2B regulation or the draft DSA, there are a lot of provisions that are not adding substantive due diligence obligations, but rather procedural requirements, like the establishment of an internal complaint handling system or mediation procedures or notice and action mechanisms. And so if you look at this pivot towards procedure and due process on platforms, it raises the question whether there is a need to a more harmonized, a more systematic set of rules on platform procedure, which, by the way, has also been suggested in US literature. If you look at this recent paper by Rory van Loo that will be published in the University of Chicago Law Review. So how could ELI contribute to this? Maybe with ELI model rules on platform procedure. This work could probably take some inspiration from the existing work on model European rules of civil procedure that is done jointly with UniDroit. And the output could be a code of conduct for setting out more detailed requirements for due process under the DSA or under the P2B regulation. Both pieces of legislation refer to such code of conduct. And because platform procedure as a sort of online dispute resolution or online complaint handling procedure also involves technical elements, this might also be done as a CEN standard or an ISO standard. And actually there is already an ISO standard on complaint handling, which however does not address specific aspects of platform procedure. So I think that could be something that ELI might address. And as you see, Article 34 of the DSA actually suggests to draft standards that might supplement the DSA rules. So to wrap it up, there are also other fields where ELI might look into. You may have seen the recent report by the European Expert Group for the Observatory on the Online Platform Economy, and maybe I should disclose that I was a co-author of this report. And in this report that was published in March, we suggested that platform power is more than just market power. The power held by platforms goes beyond the control of markets, also directly impacts businesses, consumers, and societies at large. So maybe competition law is not the only instrument for addressing platform power, but it might be necessary to look at digital platforms as infrastructures for services of general interest, which is, of course, a specific European term covering, for example, areas like mobility, education, healthcare. And if I mention these are areas that are mainly within the competence of national legislator. So if the ELI addresses these areas, that would not be a model law or a set of principles addressed to the European legislator, but rather addressed to national legislator. And that raises, of course, the question, who should be the addressee of ELI's work? And I think we will discuss this further. There would be other elements to mention, but I think I'm already over my time. So here are some further readings, and thank you very much for your attention.
Thank you, Christoph, very much for this very important presentation in line of our discussion, because it is really this. It has exactly discussed these points which we wanted to know, and somehow in which respect the work of the model rules could be used, and we have seen this examples in the European Parliament on the liability. So one of the topic which has been so extremely discussed also within our group. So this is quite interesting that somehow this topic is taken into this discussion. But now we are. I would like to ask to Gerhard Dannemann, and when we have the matter, of course, which is challenging, extremely challenging for all cities or touristic cities in Europe. Even after pandemic, the situation may be seen differently, and maybe this is a new word also for this. So we have the word of short-term rental platforms, in this world after pandemic, but also in this context, I hope with our task here, so talking about the function of the possible ELI instruments in supporting the developing of this area of law.
Thank you, Frederick. Yes, I will focus on one particular type of online platform, short-term rentals, platforms which intermediate between providers of short-term accommodation, also called hosts, and their customer called guests. This could be holiday makers, it could be business people, could be anything. Short-term rental platforms exemplify the platform economy in several ways. They operate on a highly international level. They connect hosts and guests almost globally, unhampered by trade, customs, and tariff restrictions, which apply to the international sale of goods and also to many services. And short-term rental platforms have also penetrated deeply the respective market for short-term accommodation. One particular feature which distinguishes them from other online platforms, not all of them, is they link their users physically. So guests come to the place where the accommodation is located. This may involve physical risks for both of the parties. There have been cases where guests were physically or sexually assaulted by a host, or where their privacy was violated by secret video and audio recordings. Conversely, hosts may also be exposed to similar risks, and additionally to the risk that their property will be seriously damaged by partying guests. It was therefore very much with short-term rental platforms in mind that we included Article 8, a provision on duty to protect users, into the ELI model rules. I'll just read out paragraph 2 of this provision. A platform operator who, on obtaining credible evidence of a criminal conduct of a supplier or customer to the detriment of other users, or B, conduct of a supplier or customer which is likely to cause physical injury, a violation of privacy, infringement of corporeal property, deprivation of liberty, or a violation of another similar right to the detriment of another platform user, fails to take adequate measures for the protection of the platform users, is liable for damage caused to platform users as a result of this failure. I think a rule like that is still very much needed. Another peculiarity dawned on us only after the model rules were adopted. When Christoph, Hans, and I were exploring how the ELI model rules were coping with the particular challenges posed by the COVID pandemic, I noticed that some of the biggest online platforms for short-term rentals had adopted strikingly different strategies as to how they, or more precisely, their users, should deal with the effects of the pandemic on short-term rental agreements. In particular, concerning cancellations which were related to the pandemic. I will just name 3 different types. In many cases, hosts were prohibited from letting their property to any guests. In other cases, guests were unable to travel to the property due to cancelled flights or immigration restrictions. And in yet other cases, guests might wish to cancel due to higher infection risks or current quarantine restrictions. Booking.com, one of the biggest providers, decided not to adopt any specific policy and to leave it entirely to the parties to the rental agreement and to the law which applied to this agreement to sort out the consequences which the pandemic had on the performance of these contracts. In a way, this lack of policy or guidance may disappoint some users, but as a matter of law, Booking.com appears to be on the safe side. HomeAway, a brand name which has since been taken over by Vrbo.com, took a more active role and adopted a detailed nudging policy. While they would not interfere with the rental agreement between hosts and guests, they would reward or punish hosts by improving or downgrading their ranking in search results, depending on how well they complied with HomeAway policy. Hosts who allowed their guests to reschedule their stay or who agreed to give full reimbursement of a cancelled booking would be given the equivalent of a 5-star rating for their ranking in search results. Hosts who allowed a partial reimbursement even after the customer's own cancellation period had expired would not be punished in their rankings. Hosts who insisted on full payment would be given the equivalent of a 1-star rating in their search results. All this would operate regardless of the type of COVID-related impediment and whether either party to the accommodation contract had a right to terminate or had its obligations discharged by frustration due to illegality. Ranking transparency requirements suggest that this element of nudging would have to be disclosed not only to accommodation providers, but also to potential guests. That may not have been the case. There may also be other limits to such a nudging policy. Time constraints prevent me from exploring these further, because a far greater challenge, regulatory challenge, may be posed by another one of the largest short-term rental platforms, namely Airbnb. Even before the pandemic, Airbnb had detailed regulations on what they call extenuating circumstances, which might justify a cancellation of a booking by either host or guest. These were to apply not just between Airbnb and hosts or Airbnb and guests, but also in the contractual relationship between hosts and guests, to which Airbnb is not a party, and also regardless of which domestic law would apply to this contract. These globally intended rules on extenuating circumstances were soon supplemented by a particular policy on COVID-related cancellations, which according to Airbnb websites was enacted retroactively for some contracts and remain in force until today. It reads as follows. Reservations for stays and Airbnb experiences made after 14 March 2020 will not be covered under our extenuating circumstances policy, except where the guest or host is currently sick with COVID-19. COVID-19 related circumstances not covered include transport disruptions and cancellations, travel advisories and restrictions, health advisories and quarantines, changes to applicable law, and other government mandates, such as evacuation orders, border closures, prohibitions on short-term rentals, and lockdown requirements. It can be doubted whether this policy imposed on all users by way of Airbnb standard terms can actually shape the rental agreement in the desired way. In particular, the widespread prohibition on holiday rentals as part of a government containment policy is likely to render performance of the rental contracts illegal, with the effect that Airbnb policy would in many cases incite hosts and guests to commit criminal offenses. This may be an extreme example, but shows how problematic it can become when a globally operating online platform attempts to enforce uniform policies which would shape contractual relations between users, which can potentially be governed by just about any legal system in the world. And while Airbnb alerts its users to specific legislative requirements operating in some countries, it appears that they are not thinking about different contract and consumer protection laws, which may exclude several of their policies. Where professional hosts combine accommodation with another travel service, as indicated in Airbnb's reference to Airbnb experiences in its COVID policy, could in particular in violation of Article 12.2 of the Package Travel Directive, which allows the traveler to terminate the contract because of, I quote, unavoidable and extraordinary circumstances occurring at the place of destination or its immediate vicinity and significantly affecting the performance of the package, or which significantly affect the carriage of passengers to the destination. I think you have plenty of those. More generally, Airbnb standard terms in COVID-19 place the risk on the guest, who often will be a consumer, that the performance becomes impossible, in particular because temporary bans on providing accommodation have been extended or reinstalled. Hosts who would often have to return payments under the various doctrines dealing with extenuating circumstances are thus allowed to shift the risk that the performance has become illegal onto the guests. As Airbnb has taken on the role of regulator for the effect of COVID-19 on supplier-customer contracts, parties may also place reliance on these policies being legally effective. Will such reliance on Airbnb's policy statements protect the platform user, even if a court finds later that Airbnb's representation do not conform with the law? Will compromises concluded between hosts and guests in the assumption that Airbnb statements were correct be affected by error of law? Either situation could lead to Airbnb becoming liable under its contracts with platform users for having provided rules which are subsequently rejected by the courts. Alternatively, some courts may uphold Airbnb's COVID-19 policies and be it as authentic interpretation of its extenuating policy rules, which were enforced before. And that would reinforce the platform's role as a regulator of supplier-customer contracts. At any rate, the example of Airbnb's COVID-19 policies shows that platforms which seek to provide detailed regulation of supplier-customer contracts, irrespective of which national law applies to them, operate in an area of considerable legal uncertainty. This might indeed be an area where the regulator could usefully step in and provide a legal framework for permitted platform regulation of supplier-customer contracts. Thank you for your attention, and hello to all the dear colleagues and friends who I see are listening, and I'm so sorry that we won't have time to chat over a coffee and catch up what you've been doing, but that will be left to a later date.
Thank you, Gerhard, and you showed us, of course, how much this temporary or this development of the pandemic has changed our world, and our also it has impact also on the model rules that we have drafted it in the pre-pandemic world. And of course, this is also the question how to deal with such kind of developments. But we are going further, and now we are going a little bit outside of the group of the drafters of this model rules. And I have this great pleasure here to have Mr. Prabhat Agarwal with us, and I would like to ask you exactly about our problem here. Of course, you are free to speak about this development of the European platform law, but I would like also to listen from you whether you think that such kind of work of the ELI could be really of usage for the European Commission, or what is your perspective of this work which has been done in the ELI, whether it was in any way kind of inspiration, kind of reference, even rejected, but at least taken into account, or it didn't play a role in the process of developing the European legislation on online platforms. You have a floor.
Thank you very much, Frederic. Thank you, all colleagues, for giving me the opportunity. First of all, I should say congratulations to your institute for the 10th anniversary and for the celebrations. I think I can safely say that your institute and the work of your institute is very much on the radar screen of the European policymakers, be it at the European Commission or clearly, as Christoph has already shown, in the European Parliament and other important stakeholders like the consumer protection organization. So I think if your objective was to be noticed in Brussels, clearly that objective is fully satisfied. And I think also I pay tribute to the very active participation of Christoph in the expert group for online platforms, in which of course not only these ideas have been discussed, but also many others as well. Now, on the specific case of the model rules for platforms, I think I can also safely again confirm the overall impact of your rules in the policy making process. But I want to just take the time, if I may, just to make 3 different points which may help us to just change a little bit the perspective of this conversation, and maybe in the ensuing discussion we will have some pathways that you are looking for, because as the title of the seminar suggests, you are intending to look a little bit further ahead and in the now. I hope that you will forgive me, but I would like to start with just a little bit a quote from Bismarck, which is on the sausage making process. And the law making process is very much like a sausage machine. You know, it's nice to eat the end product, hopefully, but you would not like to see how it was made. And so it is a long and complicated process. And I think I would just like to share with you a few of the internal functioning of the lawmaking process, because I think that they will help you a little bit understand how future instances of model rules or variants of these model rules might fit into the lawmaking machinery, and what contribution, for up to you to choose what kind of contribution and in which part of the policy cycle you wish to really impact most particular. Now, I think I followed the development of the model rules on online platforms, partly because, of course, in particular, Christoph has had kept us informed and involved in earlier stages. But one key difference in the way that policy development is made in the union level is, of course, the Commission has the right of initiative to propose laws in areas, but this precedes a multi-step process. And the first step in this process is actually to set political objectives. And I think this is a very important step, that is, we don't regulate or legislate on everything under the sun, but we, of course, have a legislative program which is seeks to reflect political priorities, and these political priorities reflect the democratic process that leads on. And this is the first important statement that I just want to say, is that we need to be, we inside the Commission, we spend actually quite a lot of time in discussing internally what objectives we have, and also, secondly, related to that, what the exact problem is that we are trying to fix. And this is a very long process and very intense process, and it is known as the impact assessment process in internal jargon, or the better regulation process, and in which we have a very high bar of scrutiny compared, I think, to national laws and member states, where we have to prove internally to an independent scrutiny board that there is a problem. We have to demonstrate with evidence, facts and figures, what the size of the problem is, who is affected by this problem, and we have to also demonstrate how the problem would evolve if we do nothing, if we let member states act, because bear in mind that in the European construction there are very clear and strict and important subsidiarity rules. The Union cannot act every time there is a problem. Many things are outside of our competences. In the area of platforms, for example, one important area is the issue of platform workers' employment rights. It's typically a typical problem where a lot of the competences, I'm not saying every competence, but a lot of the competences more lie in national rules. And so even if we were to identify a problem in this area, and colleagues are currently working on such an initiative, it's not absolutely guaranteed at the outset that the best answer is a European law to address them. Then the other important element that I think where the process of European lawmaking at the Commission differs, of course, it will differ from the model law, and I'm not making please don't misunderstand me that you should mirror the Commission's very complicated and very time-consuming and energy-consuming processes, but we have a very important step, which is a public consultation step on our, and this is a very important step. And for example, on the Digital Services Act package, we had some 3,500 contributions to the public consultation from many stakeholders and from all sides of the spectrum of a given problem, representing all different interests at stake, be it platforms, of course, be it business users or hotel associations. In the example of short-term rental city consumer protection advocates, of course, there's a very wide range of interested parties, also national administrations, and then there are also increasingly, I think this is a very positive thing, in these public consultations, we see an increasing interest of academic stakeholders to contribute to the consultations of the European Commission. And I think this is a very good thing, because in my view, the work of academic researchers in the field of regulation brings a very important component, which goes beyond economic considerations of the operators or consumer protection considerations of the users, or subsidiarity considerations of member states, but it brings another additional angle to it that I want to say. Now, of course, before the Commission proposes a law, then the last step after the setting or identification of problems that have to be proven to exist in a transparent way and underpinned with data, and we have to demonstrate internally that we have a real problem to fix. Then there's one other step, and this is where I will make a link to the ELI model rules, is that we are obliged to present different options for a particular solution. It is not permitted to have only one solution at the European Commission's level, but we have to instead present a range of real alternatives and compare the advantages and disadvantages of these alternatives with each other. And ideally, in the ideal world, these alternatives have built-in particular trade-offs that are then offered to the political level as alternatives from which they can choose. Is it more important to have a very high level of consumer protection in a particular area, maybe at the expense of economic considerations? You know, because of course you can have a very high level of consumer protection, but then it may be very expensive to comply with such very high levels of. So maybe economic objective is less important, or do you do it the other way around? Is the economic investment incentive more important than, or do you want to meet somewhere in the middle? And so I'm just picking two objectives, but actually in the impact assessment, we have some 20 objectives that we have to compare, and they include investments, incentives, international trade obligations, a very important one because they are equivalent to primary law in the European Union. And we have also carry out, for example, an environmental check, which is now mandatory for the different options. Are there differences? And so this is maybe and on all of these considerations, in the end, we select one option, and we say that this is the one that is, but we keep the others on record. And on this basis, then we draft laws in the proposals. And I can tell you already inside that even within this option, then particular provisions typically will have many, many versions and many versions of the final product, like in the Digital Services Act. Christoph, you mentioned Article 5.3. I can tell you internally, typically there will be at least 40, 50, 60 versions of this provision, and that exists for the entire instrument. And they are then, we have a very competent legal service inside the European Commission who have a lot of experience from the Court of Justice, where the Commission typically also intervenes in the case law. So we have very, very different versions of this. And now I want to come to my final point, to the future. So one aspect, I want to make three particular personal recommendations, and these are really my personal recommendations. That please don't take them as anything. One is, don't just focus on one model law, because it reduces the complexity of the issue to a degree that does not reflect the real alternatives that are out there. In many cases, there are many different ways of addressing a problem, and there are some advantages and some disadvantages. And by having one version, even though it looks nice and something you can send with great impact to people, but it hides the underlying complexities of choices that you have made. And these choices come, I know, through a very sophisticated deliberative process in your institute, but sometimes these choices are no longer apparent in the final product. But it is those choices that are actually interesting for the policymaker, not the final product. It's a little bit when you have children in school, it is the thinking that you want to see in the maths exam, not the final result. So in this part, I think, is maybe something that you can amplify a bit more, because you know, let us draft a law, but we are happy to see your thinking behind it. Of course, we are also happy to see your final product, but it is the way that you've arrived there which is particularly interesting. This is my first recommendation. My second recommendation, I know I'm running out of my 10-minute slot, but I have just 2 more points to make. My second recommendation is that embrace the whole breadth of objectives that the union has to pursue simultaneously. Looking at the selection of your topics, I have a feeling that your group of researchers is particularly attracted to consumer protection aspects, which is of course one important aspect, but it's not the only one. And in the area of platform regulations, there are many others out there, and it doesn't need to change. But bringing in those other aspects like competition in P2B is a very much competition or trade, as you said, and bringing this wider perspective to the lawmaking process, I think is a very useful additional thing. My third one is don't shy away from the really hard problems, and maybe even look a little bit further into the future, rather than perhaps the stuff that is already ongoing. Christoph, on your list, you mentioned laws that are actually imminently under preparation, and several of the ones that you were on your list, we are in the finalization phase, and I know it because we are of course deeply involved in them, you know. But in order to influence, I think, the thinking, I think it's good to look a little bit ahead of the curve in the course. So those are the 3 particular final. If I were to give my because this is the area where these all 3 things are things that are hard to do when you are actually in the lawmaking seat, as I am. So we have to respond to immediate action requests, and we're working actively, and there are a million constraints that are not necessarily apparent to you. And so when you compare whether the final Commission product resembles your model law, I think you are also perhaps not aware of the many internal constraints and trade-offs that are available inside, and some of them many of them are of course explained in the impact assessments, which are public, but you will see them quite late in the process, and so this might explain something. So I stop here. I hope this has given you a little bit of food for thought, but maybe I can just conclude that the work that you have done has been extremely helpful and useful, and has been scrutinized and read, and I think I think you can be very proud of the impact that the work you have done, and you have noted some high-level examples which are in the middle of the lawmaking process, and I think it's not I'm not revealing any secrets to say that we don't fully share the view of the European Parliament, and we prefer the Commission's proposal, but I'm happy in the Q&A to give some insights on why this is the case.
Thank you very much for this really fascinating speech. And this is a speech which really should be taken into account and really deeply discussed, because this 3 advices which you have given are extremely important, exactly for my question which I posted at the beginning, because this is exactly the matter: who is the addressee of our model rules and laws. And you have presented kind of European perspective on it, with all this complexity, which is quite different from the member state legislation. We are talking about this complexity of competition rules, private law rules, public law, private law, all together in looking into this internal market perspective. This is a very different way of thinking about the law as the perspective of the member state, and this is this tension between the European law and the member states' law, which is arising from here. And this is exactly the great challenge where the model rules of the European Law Institute should be put into this particular context. So I think it's really extremely important incentive for our discussion. Thank you so much. And we are, because the time is running out, we are coming now we are entering the world of the data sciences, and we are asking Rania Wazir about her perspective, a perspective also of the data scientists and science on the development in the platform laws, including our model law. So, Rania, you have the floor.
Thank you very much. I'm really delighted to be here, and it's been fascinating listening to all the other panelists see how these laws and regulations actually come to life, and all the complicated thinking that goes behind it. So I just want to consider this from the data science perspective, and I don't want to speak for all data scientists. So let me just tell you where I'm coming from. I work with smaller startups, with NGOs, and I work in the standardization. And so my take on the platform economy is basically it's great that we are regulating, but I still see too much data left in the hands of large platforms. So even though I'm a data scientist, I like data. I would like more control of who has access to it. I see still not enough choice and options for users, and I see not enough verifiability. So for me, there's a difference between what's called transparency and something I would call observability. So I would like to be able to go in and observe and validate claims that are made under transparency rules. And so my basic calls are for interoperability, stability and standardization, and data access for research in the public interest. So this is where I'm coming from, and how I see the ELI rules, the model rules. First of all, thank you so much, because they are legible and understandable to somebody who's not a lawyer, and having now plowed through several regulations, that is not a given. And what I really appreciate about them is this effort to create harmonized rules and sort of a push to standardize, and I think this is important. But what I also did, looking through the rules, I sort of went through and picked things that I would like to expand on, and or things that I wish for more. So I'm going to start with Article 1. Where we're talking about what is a platform. And here, I think actually the definition of platform is flexible enough to allow for third-party providers of recommender systems and for third-party providers of reputation systems. And I think this is important because there is a strong push to separate the pure hosting platforms from the ones that are providing some kind of a service like recommendations, like reputation systems, and having model laws already set up that can allow for this kind of flexibility is important. However, it's not clear if you allow for third-party recommenders and third-party reputation systems, how this would then fit into the liability regime. So adding third-party, which I think is the future, is where things will hopefully go. I'm not going to predict, but I'm going to wish. If you allow for third parties, there has to be a layer of the liability between the platform as a host and the suppliers and the users. So there's an extra layer of complexity in there. Moving on also to contract terms and Article 3. I think it's wonderful that in the laws, you're already asking for machine readability. This is already a step towards standardization, but in order for it to be useful, it's not enough. So if it's going to be useful, it needs to be standardized and it needs to be stable. So this is something that a lot of platform providers already do. You can have machine readable information and data, but it's incredibly unstable. It changes every few months or several times a year. And this makes it very difficult for suppliers and users to deal with these kinds of contracts, with data. Also, if you want portability of recommendation and reputation systems, which is contained in your Article 7. Again, if it's not stable and it's not standardized, machine readability is not enough. And so I would like to see added actually to these kinds of law frameworks a specific request for standards and a specific limit on the frequency of changes. How often can terms of use be changed per year? How often can data protocols be changed per year? And my next question is about the transparency requirements. Now, it's one thing to require from a platform that they inform you about the parameters they're using for creating a ranking, or even what parameters they're using for consolidating ratings. But in order for this to actually work, you need to have a way to validate those claims. Otherwise, a platform can say, we provide you this ranking because of your gender and your age group, but you have no way of checking whether that's really true. So beyond a transparency requirement, there has to be something embedded in the law that allows you to go in and check. Is this really true? Is this really correct? And this is even more important in the case of platforms, because they can personalize the recommendations and rankings. So what I see is not the same as what somebody else sees. And therefore, the whole problem of validation becomes much more difficult and really needs to be thought through when we are creating these kinds of regulations. And so my final wish is just two questions, which I would like to leave you with, and hope that maybe you can you will find answers for. And this is, first of all, how do you regulate rules and liabilities between something like a host platform and allowing third-party recommenders, allowing third-party reputation systems, because I feel that this would solve a lot of problems also for users, giving them more choice, giving them more options, and create the kind of competition, which could also be competition in terms of how data friendly. You might be able to choose one recommender system because it doesn't profile you versus other recommender systems which do. So how do you regulate the rules and liabilities between a host platform and third-party recommenders that you put on top of it? And my second question to you is how can you create rules which allow the validation of claims made under transparency rules? And I would like to leave you with these questions because I'm much more fascinated by what you would have to say.
Thank you, Rania, very much, and also for this inspiring questions here. And I think there is a field we will need a long time to discuss all this issue, which also challenges which you have put on us and in this discussion. Thank you so much. So now we are. Thank you to all panelists for this extremely, I think, inspiring discussion. And I think we really got a perspective, and I think also from the perspective of the ELI, being now the member of the executive committee, I can say that there's something which we should very seriously discuss about our future development and the strategy of the ELI and strategy of the documents which are going to be produced in the European Law Institute. But now we are starting with the questions and answers. Yes, the first question which we got from Mrs. Denisa Walkowa, yeah, it is a little bit far from our probably from our field of discussion here, because this is the question whether we know any countries which where the judicial acts are signed with a qualified electronic signature. In Bulgaria, it could be the case. I don't know whether we are able to answer this question. I don't know whether somebody of you, but we are a little bit outside. It is outside of our platform field. So we are mostly here, sitting here, the private law specialist. It is also an interesting question for it. So for the judgments, I don't think so. There is for statutes. I think it is possible, but I don't want to. In Poland, for example, I don't want to enter this field, which is quite far from our competence, I guess. So I'm sorry that probably we are not able really to provide here kind of answer. But we have an second. It was the second question, I think, of Richard Ray, and he was asking. That the platform's law is impacting in a very detrimental way a lot of areas, in areas of holidays and areas of transportation, other kind of services. So it has a great social and according to the question, the negative impact on our societies. And there's the question: should the law somehow respond to this challenge? As we are, I understand it a little bit as a criticism on our text, that it does not have this deep social policy in somehow respond to this challenge to the society, which has been done by the platform. I don't know whether Aneta would like to answer such kind of question.
Yes, thank you. Well, I'm having a problem answering this question because I'm having a problem to easily agree to what it seems rather very negative judgment on the platform's impact on the society. And especially if it deals with services, because of course, this is what we see the most. Cities that impose restrictions as to operation of Airbnb, for example, in order to prevent the rise in rents of apartments and availability of apartments. Berlin, I think, was one of them, for sure Barcelona. But what we don't see, because it's not being so widely discussed, because it's on a different scale and much more dispersed, is the places which actually gain from platforms. Because the changes on the market came with, for example, all-inclusive hotels and type of vacations. And suddenly Airbnb helped little places which were cut off from the tourists, which were locked in all-inclusive hotels, to start up again or restart their businesses. The same, platforms give easy entrance to the market. And of course, that might be then controlled by the platform, but the market channel through the platform might be almost limitless and available to little companies or parties that wouldn't have ever a chance to gain such access without platforms. So for those of you who know me, I'm feeling rather strongly about the protective aspect of introducing legislation, also in terms of platform regulations. But here I'm a little bit hesitant because I see it in a more nuanced way than Robert suggests. And actually, I would be a little bit hesitant just focusing on one side of the impact that platforms have on society, which is undeniable. So here I would rather suggest to treat lightly, because with strong regulation or over-regulation, one might lose the positive impact that the platforms definitely have, which is not so visible at the first sight, but it's there. So I don't think we are shy. We were too shy when it came to discussing this this sort of impact, and that was definitely present during our discussions, if you recall. Thanks.
Thank you, Aneta, very much for this broad answer. Hugh Bill has already delivered sources for the electronic signature issue. And now we are, thank you, Hugh, for helping us in this. And now the question of Ilaria Pretelli. Have you considered adopting a uniform connecting factor protecting platform users? It seems that various connecting factors are used in the different regulations, not always consistent with each other. Many thanks. Gerhard wants to answer here, I think, and then I would like maybe Hans to comment shortly about this. Yeah, Gerhard.
I've posted a written reply along the lines of there are many different types of protection which will be required. You can simply read an online review which is inaccurate and then go to a local shop and buy the product, and you somehow think, I'm being let down by this customer review, but you were never really on the platform or interacting. Or you can be physically attacked by an Airbnb host. And these are very, very different protective levels. So I'm afraid we will need different ways of defining and connecting users to platforms, simply because the interests are very, very different.
But if I may shortly intervene only, of course, in our model rule, we were trying to create somehow of consistent system of
If you look up model rules, we have lots and lots of protection of people built in, but this may be protection against unfair reviews, protection against misleading ranking of reviews, protection against being attacked, protection of somebody. We're later looking at protection of some Amazon suppliers being deprioritized or being delisted. There are many, many different situations in which legitimate interests of platform users are being endangered, but the situations are very, very different. So I don't know how we could formulate one set of how we connect people to a platform and then they're protected, but maybe I've misunderstood the question.
Hans, could you also comment this? Thank you.
There's so many points to comment on. Therefore, I'm very, I have to be selective. My excuses for that. You may have noted that the DSA does not give a positive claim for damages, for breaches of all the rules under the DSA. Only there's, of course, this traditional limitation stemming from the e-commerce directive. And therefore, the whole system relies very much that there is a claim for damages somewhere out there, of course, out there in national laws. And that's perhaps a point where also ELI could go a little bit further. I would really be tempted to check whether the national laws in Europe grant appropriate claims for damages when platform operators breach duties under the Digital Services Act. And sorry for making again proposals to, in inverted commas, improve the DSA. At least it could have some better interfaces for that, or perhaps even in a more general rule on whatever sanctions, penalties, and so on, express the expectation that all national legal systems provide a claim for damages, at least in important cases. I'm not drafting here, of course. That's perhaps one of the steps where the ELI model rooms were brave, as Prabhat asked for, because they have a very general claim for damages for breach of all the duties that protect individual persons. And that's perhaps the next step to see how this really is in the member states and perhaps even beyond. Thank you, and sorry for not answering all the other questions.
As Frederik's picture is frozen, and I've seen that Prabhat has raised his hand, I suggest that Prabhat has the floor.
Yeah, I just wanted to make a very short comment, and I think these are all great ideas. I think one point maybe on the, because now we are discussing a little bit the Digital Services Act, and I didn't deliberately talk about it too much because I think we would need a bit more time than we have available. I would be very happy to explain some of the choices which were fundamentally different from the starting point or from the Digital Services Act maybe. And there's a little bit of a path dependency on how you came about, and which is not a problem. And I said it in the chat as well. It's just a different trajectory, and they have some intersections. And these intersections are interesting. But it's also interesting to know the DSA takes over the liability exemptions from the e-commerce directive, of course. And one key point about it is that that this covers all types of illegal content, all types of liability, both civil and criminal liability. And so in the context of claim for damages, it's not only about damages, it's also about criminal liability. And it is this strong harmonizing element that we wanted to preserve, precisely because platforms engage in all sorts of intermediation functions, not only in civil but also in criminal. And it's very important from our perspective to maintain this horizontal nature. So this is just one of the aspects which I think is important to just show. And this was a starting parameter for us to preserve this very horizontal nature. And I think and another occasion, I'd be very happy to go into deeper analysis and comparisons of our starting and endpoints and the intersections where we see them. But just I couldn't resist to pick up this one small point because, of course, claims for damages only relate to a part of the DSA, which is maybe politically in the context of terrorism and illegal hate speech, maybe not even wasn't perhaps the first driver of our initiative. Just wanted to highlight that.
Thank you very much. I'm back. I had sorry, I had this internet interruption because my connection is very unstable. I would like also, we are approaching the end of our webinar, but last question, which I would like to also direct to Christoph Busch from Jana Campos Carvalho. I'm curious if you could choose one rule of the ELI model rules to include in the DSA, which one would you include? What would be more important in your view? I think this is a good question for Christoph. Christoph, yeah, you have a floor.
Yeah, that's really a tough one. Of course, I like all of them because we worked so hard on all of them, and each rule has its story, you could say. But let me choose two, if I may. One is Article 20 on platform liability, and I think it's not a coincidence that the European Parliament looked of all our rules at this one, because I think that's really a crucial issue, and I think that's also an innovation in our draft that we presented here. So I think Article 20 should be on a board. And the other one, which is very dear to my heart, is the rule on reputation systems, a topic which is not addressed in the DSA at all. Maybe it should be addressed somewhere else, but I think it should be addressed somewhere, be it in the guidance of the Unfair Commercial Practices Directive or somewhere else. I think there's this very close link also between digital identities, and there is EU activity going on regarding digital identities, and online reputation linked to a certain digital identity. And I think that's a topic that I see becoming more important in the future. So that should be taken on board somewhere, maybe not in the DSA, but somewhere.
Thank you. Thank you, Christoph, so much indeed. And I think our time is over for the seminar today. But I think this is something which we can discuss and we will discuss for a long time. And we had here two very important discussions. One is about the future of the online platforms law, and the second one is about the future of the different instruments of the ELI and the function of the ELI in the community. And I think we have to really, Pascal Pichonnat has commented also about it and about the function of the ELI instruments. Yes, this is something which indeed must be very well reflected for future, because there is, I think, a gap between the member states legislation and the European Union legislation, and also the legislation of other states which are in Europe but are not members of the European Union. But we have to, ELI provides this unique opportunity to fill this gap. And when we have to find out the instruments which are capable to fulfill this function. So thank you very much to all panelists for this extremely interesting discussion for me, and thank you very much for having accepted our invitation to be here with us in this evening and having this really, I think, fruitful discussion. And to all participants, and also to everybody who also enriched our discussion with questions, but also to all of you who have been with us, because yeah, this is a discussion which must continue. Thank you so much, very much for this evening, and we will see us in
our next webinars of the Institute. Thank you very much.
Bye-bye.
Bye-bye.